Hi and welcome. I'm Leslie with the New Mexico Small Business Development Center, and let's get started. 6 traps to avoid when starting a business. That's what we're here to learn about today. I'm here with Ian Alden, who's going to be presenting the webinar for everyone. He is a practicing attorney here in New Mexico. He loves questions. He picks them up throughout the entire webinar. So if you have any information that you want to learn about or anything specific, type it into the Q&A and he will pick them up just as quickly as possible. New Mexico Small Business Development Center wants to remind all New Mexico small businesses about the risk to their cybersecurity. We have a lot of cybersecurity webinars that are pre-recorded on demand on our YouTube channel, and we'll send that information over if you'd like to watch those at your leisure. With all that, Ian, I am going to turn it over to you.
Thanks so much, Leslie, and good afternoon, everyone. It's good to be back with you again for this week's workshop. Let's get started. 6 traps to avoid when starting a business. So we're going to start going through these 6 traps to avoid, and I've got 6-ish helpful tips to get you there. But before we do, a bit of housekeeping stuff. As you all know, the Delta variant is currently sweeping across the land. We're not out of the woods yet as far as COVID-19. The mask mandate here in New Mexico is reinstated, and who knows where we're going from here. So it's as important now as it ever was to maintain a COVID-safe workplace. There's a lot of resources here on this slide for you small businesses, especially to access, to get some information from, to be able to maintain a COVID-safe workplace that's compliant with the latest regulations and advice. So be sure to check all that out so that you can do your part and we can get past this thing finally, eventually, hopefully. Some other notes. Please make sure your microphone stays muted. It should be muted by default, but if for whatever reason you happen to accidentally unmute it, make sure it gets muted. Make sure your Zoom ratio is set to fit window. That's so you can see everything on these slides. We're going to be using the Q&A function to take questions. So there's the Q&A function here in Zoom. Feel free to ask your questions in there and I'll be taking them as I go. Don't feel the need to wait until the end of the presentation. If you've got a question, just go ahead and throw it out there. I'm more than happy to answer them as they come. If you do decide to wait until the end, be sure to write down the slide number your question relates to. You can see the slide number in the bottom right-hand corner of the screen. So we've got some other great workshops coming up with the SBDC. Even this week, some great ones on how am I being found on Google? What are my customers typing? Great if you're trying to figure out how to get yourself prioritized in the search engines. 3 steps to attracting and retaining customers, which is vital for any business, small or large. Win-win contracts, negotiate better business deals. I'm going to be running that one on Wednesday. Putting your business plan into practice, part 2. There's a lot of great resources, these and other workshops, as well as no-cost business counseling, loan application assistance. There's a lot of great things that the SBDC here in New Mexico is offering. So be sure to check out nmsbdc.org to see what resources are available to you. So there's 6 traps I'm going to cover here, and obviously there's as many or as few as you want based on how you broaden or narrow these categories, but the general idea is there's these 6 that I see time and again with my own clients. To give you a bit of background, I'm a business and tax attorney and consultant. I work with clients, small and mid-sized businesses in various life cycles of the business. So starting up, growing, growth cycles, bringing on investors, selling, retiring, liquidation, shutting down, you name it. And so these 6 traps are things that I really commonly see, that it's so helpful to know these in advance and avoid them, because if you're trying to fix a problem after it's already become a problem, results are going to be mixed at best. But if you can avoid the problem altogether, that's obviously better. So the first one we're going to jump into is misusing LLCs or corporations. Just a general primer, these are business entities that protect their owners from personal liability for the debts and obligations of the businesses. if the businesses are properly set up and operated. And so this means a few things. First, you need to set them up before you start the business. I mean, obviously, if you're a sole proprietor, you can start an LLC at any time, but they're not going to protect you from liability for things you did before you started the LLC. So you want to set them up proactively before you start doing business. And I'm going to cover a few different things that can lead to what's called piercing the corporate veil, which I'll explain in a minute. I'm sure a bunch of you have heard that term thrown about, but some things that you really need to avoid when you're using an LLC or a corporation. They're practically interchangeable for this purpose. You can't use the company's bank account for personal expenses. Don't pay your Netflix out of the company account. Don't pay your mortgage, et cetera, et cetera. The company's bank account needs to be used specifically for the income and expenses of the business. Vice versa, you really don't want to be using your personal bank account to cash checks that were written to the business or to pay expenses of the business. Doing any of this is what is commonly called co-mingling assets. And if you do that, and so, someone sues the LLC and they get a judgment against the LLC, and the LLC has no money, it's defunct, and they go to the court and say, Your Honor, I want to go after the owner of that LLC to satisfy this judgment. The court's going to look at the way you were running that LLC. And if they see, for example, that you're commingling the assets, they're going to say, okay, the owner clearly wasn't treating this LLC as something separate from them. They're treating it as just an extension of their person. So fair is fair. I'm going to let this person go after the owner of the LLC. It's such a common trap that people fall into. They think, oh, it doesn't matter. It's my LLC. I own it completely. What's the harm in paying my personal stuff out of the LLC's bank account? The harm is you lose the limited liability protections. So really, really, really encourage you not to do that. The next thing, using the company for unrelated business or personal activities. And I'll give you an example of this. Let's say you're one person. You start an LLC that you're not even sure what you're going to do with, but then you run an online business selling various products, let's say cosmetics. You're selling them through your LLC online. But then let's say you also have this great opportunity to buy into a local restaurant chain. And so you use the same LLC for that. You're using this LLC for very unrelated things, with the only commonality being you. The court's going to look at that and say, okay, this LLC is just an extension of their person because it doesn't really exist for any one set purpose. It's just doing whatever the owner wants. It's called the alter ego or instrumentality rule. And if the court finds that your LLC is just your alter ego, they will hold you personally responsible for the debts and obligations of that LLC. So don't do that. And then these next two, I'm going to go over both at the same time because they actually both fall under this theory of what's called undercapitalization. Basically, if you have regular monthly expenses or debts that are coming up and are due and payable, maybe you've got a balloon payment or something, and you deliberately run the LLC's bank account dry by taking out as distributions or draws everything that's in the bank account. And so the bank account is empty. There's nothing for the creditors, for the people you pay regular expenses to, the landlords to go after, because you just empty the bank account. That is a deliberate form of undercapitalization. You have undercapitalized the LLC intentionally. And so the court's going to look at that and say, fair is fair, you can go after the owner. That's one form of undercapitalization, but another one that really slips by people. If you are operating a business that's public facing, that provides services, that maybe has a physical location, a storefront or whatever, that can create a potential reasonably foreseeable risk of harm. And an example of this is you run a retail store, you're mopping the floors, whatever, someone slips and falls. And if you don't have insurance that would cover yourself in that kind of eventuality, and you don't have enough money in your bank account to really cover it, that's another form of undercapitalization under a more liberal interpretation of the law. And so, if you don't have the insurance that could cover such a claim, you don't have any other money, same thing, the court might look at that and say, fair is fair, you can go after the owner. So one piece of advice I give business owners every single time I have a consultation with these topics in mind is have good insurance that is applicable to what your business does and the risks it can potentially incur. So if you've got that commercial storefront, have some commercial liability insurance. If you're providing services like accounting services, maybe errors and omissions insurance. If you're a lawyer, malpractice, which is just a form of E&O, but have insurance that's suited to your business, because failure to do so could be seen as undercapitalization. And so that's misusing LLCs in a nutshell. A lot of people just assume that, oh, I've got this LLC, that's all I need. It's going to protect me. I don't need anything else. I don't need insurance. I don't really need to take care of how I run the LLC. I have it, and that's enough. And that is just so far from the truth. And so that is the first trap I wanted to point out to you all and make sure that you avoid. The second, and this is the bulk, I want to say the vast majority of the dispute resolution cases that I take on personally are over lease agreements. Don't sign leases that lock you down because you're starting a business, or maybe you've got a business, you're in a growth cycle, and maybe it's time to stop working from home and start working in a commercial space. So you think, okay, I'm going to go lease property. Let me get to the end of this slide and then I'll take the question in there. So you're going to lease property, and under the right circumstances, that can help you grow your business. You need space for adding employees, for having customers visit you. Leasing property isn't necessarily a death trap, but leasing property under the wrong circumstances can tie a business down in very untenable situations, can bleed that business dry, can set it up for failure, and then can drag the owner down with the business. And I'm going to cover that a little bit later in personal guarantees, but a bad lease agreement can sink a business owner. So I'm going to take the first question. The question is, what type of good insurance do you advise for international trade? And that's actually a really good question. I don't have an easy answer to. I would assume that's some subset of errors and omissions insurance, but I'm not a licensed insurance broker. And so what I usually tell my clients is, okay, you've got a general sense of what your business does. We've chatted about this. We've figured out kind of the contours of what it does. Now go talk to an insurance broker. Talk to someone who's licensed and qualified to advise you on the different types of insurance your business will need. And then get a second opinion if you want, but then go with that. And that's what I'd recommend here. But leasing property in the wrong circumstances, let's have a look at what this looks like. So most commercial leases, they're for a term of 3 to 5 years. Some are longer, some can last 5 to 10 years. I've got another question coming in. Oh, never mind. So some leases can last 5 to 10 years or more. I've seen leases for 20 years. I saw one lease for 99 years. I'm pretty sure the United States leased property from Cuba under a 99-year lease. That's a whole nother thing. But apart from leases entered into by the government, I have never in my own practice seen a 99-year lease. I know that there are some uses for them. There's perpetual land leases and things like that. But bottom line, for your small business, you should be thinking about the next 3 to 5 years for growth. Not 5 to 10, not 10 to 20, not 20 to 30, 3 to 5. You should be focusing on blocks of that size. Obviously, if you're already past that phase where you've grown, you're very well established, maybe you're at the point where you're already franchising and you have a better sense of your needs and your growth, maybe you can sign longer leases. But I want you to really think about this when you sign a commercial lease. Don't fall into the trap of accepting whatever term the landlord is insisting is standard, because every lease out there is negotiable. Every single one. If they tell you it's not negotiable, you can find another property where the lease is negotiable. We're not in a desert of commercial properties. There's quite a few that are up for rent right now. I just checked the listings earlier today. So don't feel like you have to go with the first option. Some other things to consider: many leases are triple net leases, meaning you're paying base rent plus the lessor's property taxes, property insurance, and what's called common area maintenance fees. If you're in a strip mall or a complex with a common area, which includes parking lots, seating areas, maybe some landscaped areas, in a triple net lease, you're paying all of that. You're paying the base rent, you're paying your respective share of the landlord's property taxes, the landlord's property insurance, in addition to your own renter's insurance. They're not the same thing. You're paying the landlord's insurance, and you'll separately have to buy your own insurance. And then you're also paying common area maintenance fees. So if you're looking at a lease and it says triple net, understand that's what it means, and understand that you're going to be able to know the base rent in that lease, but the other stuff, it's always going to be estimates. The landlord can give you an estimate of their property taxes, of their property insurance, and the other fees, but you're opening yourself up to variable costs that really can vary, especially when we're talking about maintenance, common area maintenance or maintenance of the building's HVAC or roof. If the lease provides that you as the lessee are paying some share of that, just know that your payments can be wildly variable. So that's a trap to look out for. And if you're not comfortable with that, find a lease that isn't triple net. They are out there. Lots of commercial leases are not triple net. Maybe you can negotiate one with the landlord in exchange for a higher base rent, but be aware of what you're walking into with these leases. And then most leases for new businesses require the owners to sign a personal guarantee by which the owner is committing to pay the entire amount of the lease plus collection costs and other fees if the tenant defaults. There's reasons for that. If you start a brand new LLC, there's a substantial risk that you never really get it off the ground. And so the landlord wants some protection, but just know that those personal guarantees are an onerous thing, and they're very common in commercial leases. So this goes back to some other points I was making. Don't sign a lease for an extremely long term, because if you're going to personally guarantee a lease for a business that may or may not make it, you want that lease term to be as short as possible. So that way, if the business goes under and you're obligated for the whole rest of the lease term, you don't want to be obligated for 20 more years of a lease. I mean, obviously the landlord has to relet it and so on and so forth, but minimize your potential exposure by having a shorter lease term. There's a flip side to that, which is that the landlord could raise rent after the term. They could give you the boot, they could sell the property, but it's a risk you'll have to balance with the risk of personal exposure. If that all makes sense. We've got a question. Oh, never mind. That's just another comment. So another thing to consider here, most commercial leases do not allow the lessee to break the lease early under any circumstances without the approval of the lessor. That should say without, but the idea is the lessor, the landlord, has to approve if you want to break the lease early, and they're typically never going to do that unless you're on very good personal terms with them. Many leases do not allow the lessee to sublet or assign the lease to someone else. So your commercial lease, the landlord might say, you're stuck with it. We're not going to let you find someone else to stand in your place. We're just going to go after you for damages if your business goes under. Many leases grant to the lessor a landlord's lien in whatever assets are kept in the premises. What that means is, if you've got all your business assets, your computers, furniture, fixtures, whatever in the property, and then you default on the lease, the landlord has the right to take and seize that property and put it towards whatever rent you still owe under the term. I say all this, and then I'm underlining this point to drive it home. And I'm not bashing commercial landlords here, but this is just a basic fact. Many commercial leases have terms that would be considered predatory or unconscionable in consumer contexts. For consumer leases, for residential leases, there's an entire section of New Mexico law that's dedicated to tenant protections that govern what a landlord can and cannot do, what they cannot put in the lease. They give tenant rights. That's for residential properties. And one of the biggest mistakes I see people make is thinking that I have that same protection when I lease a commercial space. You do not. Those statutes apply very specifically to residential leases. There's still a thing called unconscionability even in commercial leases, but it's very hard to prove that your commercial lease is unconscionable, and most courts will just defer to the lease and say, You signed it, you're a business, you should have bargaining power. You could have hired a lawyer to look at your lease. So we're holding you responsible for it. So just know that commercial leases are one of the biggest traps, and they are one of the biggest reasons many businesses fail, is because if you're a brand new business, you've got fluctuating income. Your income's going to go up, it's going to go down, but leases the landlord's going to expect to get paid what they're owed on time every time without fail. They're not typically sympathetic to you saying it's a slow month, but next month will be faster. And once the landlord initiates default proceedings, it sets off a chain reaction that can really sink a business. So, if you have questions about this, if you have questions about your lease that you're considering or that you've already signed, use your resources, hire a lawyer, reach out to the SBDC for some guidance or for them to point you in the right direction. But really don't sign these without thinking about it. Some other things that you might do before you sign a lease. Look at the past history of the building that you're about to rent and the businesses that occupied it. And here's a great example. If you were renting a space to start a new restaurant, and that space had 5 restaurants that all failed within a year, maybe it's the space. Maybe it's it could be something as innocuous as not enough parking or really difficult to access from the road. Maybe you can't make left turns into the parking lot. Maybe you can't even see it properly from the road. Maybe there's some restriction on signage. But if you're about to rent a building that has had a string of failures before it, that should be a red flag to you. And so you really need to make sure that you're covering your bases and that you have a good exit strategy with that lease. Personal guarantees, again, they're typically required when you're signing a lease with a brand new LLC, but one negotiating tactic I've taken that has had some success is negotiating a personal guarantee that expires after a certain period of time, whether that's 1 year, 2 years, 3 years, whatever. Having a personal guarantee that expires gives you some breathing room down the road. Make sure the lease is assignable or can be submitted or subletted. Assigning means someone else is going to take over your responsibility as the tenant. Subletted means you're going to sublease the property to someone else. In an assignment context, whoever takes over your space will pay the landlord directly. In a subletting context, they are subleasing the property from you. They'll pay you, you pay the landlord. Those are 2 options that you can consider. But if the landlord insists on consenting to any proposed assignment or sublease, make sure it's written in there that their consent shall not be unreasonably withheld. 5 very simple words that have a lot of legal meaning, because it means that the landlord can't just arbitrarily say, no, I'm not going to let you do that. They have to have an actual reason for declining it. Another common trap in these leases, be careful not to assume all the repair obligations for the building. A lot of commercial landlords will sneak this in here towards the middle of the document. They'll assume you don't even read that far, but they'll say that the lessee is responsible for keeping the building in good standing and working condition, including everything. They will try and pass off the responsibility for you to replace the roof, the HVAC system, structural elements, exterior plumbing, electrical, you name it. Landlords will try and pawn that off on the tenants. And if you're renting a building for 5 years, and then you have to replace the roof, that is something that adds value to that building for 20 years. And so what's going to happen is either you're going to get the boot, and the landlord will release the space to someone else, or they'll sell the space because it's got a new roof, or they'll raise your rent after the initial lease term because all of a sudden you're leasing a building with a brand new roof. What a value to you. The roof that you just personally replaced, it inures to the benefit of the landlord. And so one thing that I do in every lease review is I make sure my clients understand and negotiate away when possible these repair obligations, because you don't want to be on the hook to replace something that's going to cost you 20 or 30 grand so that the landlord can benefit. Finally, and I can't emphasize this point enough, don't be afraid to walk away. No deal is better than a bad deal when it comes to these leases, and I cannot stress that enough. Feel free to walk away. There's other properties out there. I had a client who walked away from one last week because they were insisting on everything I just outlined here. They were insisting that my client as the lessee replace the roof, and the roof was in bad need of replacement. The landlord is going to get the full benefit from that roof replacement, and then the landlord is going to pass the added value of the building back onto my client in the form of increased rent. It is nonsense. So don't be afraid to walk away. The next thing we're going to cover here is personal guarantees. As I mentioned, a personal guarantee, it's an agreement to be personally liable for the debts of or obligations of another. That's the long and short of it. You are agreeing to be responsible for someone else's debts in the event that they don't pay. And so you commonly see this with LLCs, especially brand new ones, and especially when you're signing a lease or you're trying to get credit. The business owner is going to have to personally guarantee the debts and obligations of the business. That's true for SBA loans. That's true for, well, most SBA loans. That's true for most commercial leases, bank loans, you name it. So that's what a personal guarantee is. They're pretty unavoidable in a lot of contexts. Like I said, commercial leases, etc. But even though they're often unavoidable, they're avoidable in a lot of other contexts. And if they're unavoidable, you can negotiate to lessen the burden on yourself. And this is really important. Don't just assume, oh, this is in here, it's take it or leave it, there's nothing I can do about it. Maybe that's true. Maybe that's the negotiating position of the landlord or the lender or whatever, but maybe, and in some cases you can, negotiate away the personal guarantee in exchange for higher interest rates, higher down payments or deposits, you name it. There's ways around this if you're creative and you have a good negotiating partner on the other side. If your landlord's willing to negotiate with you, great. And if they're not willing to negotiate, if they're the take it or leave it kind, again, you just have to consider if that's the arrangement you want or if you want to keep shopping, because there's always other commercial properties out there. But really, that's commercial guarantees in a nutshell. Trying to think if there's anything else to cover. Oh, there's one other thing that I should mention about personal guarantees, and this is a big misconception that businesses have. So let's say you have that brand new LLC. You sign that commercial lease. You sign a personal guarantee where you're personally going to honor the lease if the LLC fails. And then let's say the LLC fails and the landlord is going to go after the LLC and it's going to go after you personally as the guarantor. You could shut the LLC according to state law. You could declare bankruptcy on behalf of the LLC and then shut it according to state law. Either way, though, it's not going to invalidate that personal guarantee. That guarantee will survive the collapse of the LLC. And so I have clients who frequently ask me, how do I get out of this guarantee? And they don't like the answers because it's either negotiated out with some kind of settlement with the landlord or other party, or you can personally declare bankruptcy, because a personal guarantee is a debt obligation in its own right. And it's an obligation of whoever signs the guarantee, which would be you as the business owner. So if the business goes under and then you personally go through bankruptcy, typically a Chapter 7, maybe a Chapter 13, but in any event, if you go the bankruptcy route personally, you can include the guarantee as a debt that could then be discharged in bankruptcy. The trade-off to that is obvious. Your credit is in tatters. If it's a Chapter 7 bankruptcy, you only get to keep so much of your property and belongings. The rest has to go to pay the creditors. So it's not really an option for a lot of people, especially with means testing now, but that is one way to get rid of your personal guarantee. If you are truly underwater and you have no way out, no chance of paying what you've guaranteed, bankruptcy might be an option for you. At that point, I would say consult a bankruptcy attorney, but that's how you get rid of a personal guarantee.